Viewers, today I'll speak about child arrangement application, access to child, and how you can apply further leave to remain on the basis of your access to child to a child who is settled or British citizen in the UK. Now, child arrangement application, I'll give you some tips about who want to make this application. So let me explain what is child arrangement application. Child arrangement application is basically an application to have contact or otherwise spend time with the children. So it's a family law application. So I was in court today, and what from my experience, I will share my experience to how you can settle yourself in respect of contact and how quickly you can resolve this issue. And from my experience and what actually the advisor always even in the court from the judges advise the parents that you should put your personal issues separate than your family issue than your children issue, because children matter is always you should give the priority of your children interest. Now you may have angry with the other party, you may have some allegation against each other, but when it's come to in the children matter, I think every single party, every single parents should give priority, and the primary consideration should be the children best interest, and that can be served when both party come forward with an intention to serve the best interest of children. And from today experience, what I want to share that the matter what I was instructed is a matter which supposed to go so long, which is necessary to 2 3 days hearing. For example, when the allegation is necessary to fact finding hearing, it is necessary to welfare hearing, and lots of work involved for solicitor drafting the schedule of allegation. However, once I was in the court, I start negotiate with the other parents, other solicitor, and that's matter been settled before we enter to the court. That's what is very important. If you are representing yourself, the best option for you is, or if you have a solicitor, the best option to engage in discussion with the other parents and get reach an agreement in terms of your contract. And when both parents put the children first, this matter doesn't need to go trial, doesn't need to pay so much money to the solicitor or the counsel, so much stress you don't need to take. Easily you can settle this matter. Now, in terms of child arrangement application, and also as I already briefed that you need to start the application. If you want to make the child arrangement application, first you need to attend Miami is mediation. If mediation fail, you can apply to the court. You need to submit the application form, which is C100. You need to pay court fee, probably 140 144. If you can't pay, if you are on benefit, you can claim help with the fee, so you don't need to pay the court fee. Once you submit the application, then the court will immediately order a direction for first appointment dispute resolution hearing. Normally, child arrangement application, there are a couple of hearing, the dispute resolution hearing, there may be a fact-finding hearing, there may be direction hearing, there may be welfare hearing for the final hearing. So there are a couple of hearing involved, and it is expensive, the child arrangement application. That's the reason I think end of the day either both parents get contact, or one person will not going to get net contract, direct contact, if it is a severe allegation unestablished the allegation. Even worse scenario, still the other parents will get indirect contact. So some form of contact. So it is advisable, and I always encourage to engage in children life, both parents, to serve the best interest, to engage in negotiation, discussion, and settle this matter, reach an agreement out of the court, and then you can go to the court and ask the court to approve the consent order. And if the court and the CAFCAS agree, This is the end of the matter. Now, the other matter involved in which is further leave to remain. Some people who came in the UK have a child with the other partner, and unfortunately, the relationship doesn't work. So, in that situation, if you have a child who is settled in the UK or a British citizen, you can make an application in the UK on the basis of private and family life, which is FLRFP. Now, if you want to make a FLRFP, you must establish to the Home Office that you have access to the child. Now, if you just tell them I have a children, I have access to the child, it will not work. You need to establish and provide a documentary evidence. One of the issue where many people make an application to the court and get a child element order, their final order or a interim child element order, and what they do, they just send this order to the Home Office as evidence. But very careful, you can't disclose the child element application, child element order to any public authority, public body or person without permission of the court. Even other parents, if they give permission, you can't disclose it. You need permission from the court. So because this is a private and confidential matter. So what you need to do when you make the first application, you need to seek permission from the court. So what you can, if you are represented by yourself, if you are litigation in person, then you can ask the court that I am seeking permission to disclose the child element order to the Home Office, and you can give an explanation that I have an application pending before the Home Office and therefore I need to disclose it. Now, some people have a prejudice that if I tell this, the probably court will think that I just want to get a visa in the UK, that's why I came to the court. Well, this is not to be the case, because the under the Children Act section 1, the best interest of the children is primary consideration. And if you are in the UK as a parent of a child, this will serve the best interest of the children. Therefore, to be in the UK, it is best interest of the children, and that is the section 1 of the Children Act said. And therefore, if this is the situation, then the court will, of course, permit you to disclose this court order to the Home Office. Once you get the permission, then you can send this court order to the Home Office as you can establish that you are exercising access to the child, that is, you are looking after the child, or if you pay any maintenance, you can provide this evidence. Alternatively, if you don't have a court application, then you can, if you have a good relation with the mother or the father, then father and mother can write a letter confirming that you have access to the child, and that is also a sufficient evidence. But the case scenario where the father or mother are unwilling to provide assistance, because some parents doesn't want father or the mother to be in the UK, so they don't want to assist them, then you have no option to rather than to go to the court to make an application. So once you establish your access either by a letter from the other parents or by way of a court order, then you can make an application to the Home Office on the basis of FLRFP. You need to make complete an application online FLRFP and submit it, and then you can provide all these, upload in the system all these documents. I have many video in this YouTube channel how to upload document, what document you need to upload for FLRFP or human rights application. So this is all about today, brief information about family law and immigration law. Good time for everyone.